Good afternoon, everyone. Thank you for joining us for today's webinar, How Criminal Convictions Can Affect Immigration Status. My name is Wyatt Fraser. I'm Legal Aid Alberta's Engagement Advisor. I'll be helping to make sure everything runs smoothly today. So before we get started, I did want to speak to a few bits of housekeeping. So by default, your microphones and cameras are disabled, but you are able to engage with us and ask questions using the Q&A feature that's enabled in Teams. You can access this feature by clicking on the Q&A button at the top of your Teams window on your desktop, or from the bottom menu if you're joining us from mobile. So we will have some time for questions at the end, and we will try our best to get to as many questions as we can. But we did just want to let you know that due to the size of today's audience, we might not be able to get to all questions. And if that's the case, we do apologize. Also to note, we're only able to provide general information during the question and answer period, so we're not able to answer any specific legal advice questions. If you need to apply for assistance from Legal Aid for an immigration matter, please contact us at 1-866-845-3425. If you experience any audio or visual issues, we always recommend trying to leave and then rejoin the session, and that will typically resolve most of the issues. We are recording today's training, and it will be available online later next week from our website. A copy of today's presentation will be shared via email with all attendees, and we're also going to share a link near the end for you to complete a quick survey just to share your feedback to let us know about your thoughts for today's webinar and help us get ideas for future webinars as well. We want to start by saying we respectfully acknowledge that we are situated on the ancestral and traditional territory and travel routes of many peoples, including those on the lands of Treaties 4, 6, 7, 8, and 10, the Blackfoot Confederacy, Kainai, Piikani, Siksika, Dene, Saulteaux, Nakota Sioux, Stoney Nakoda, Tsuut'ina Nation, Métis people, and the traditional travel route of the Cree. In an act of reconciliation and gratitude, we acknowledge all Indigenous, First Nation, Métis, and Inuit peoples who have lived in and cared for these lands for generations. We express our continued thanks to be able to work on these lands and represent Albertans in this territory. And with that, I'll turn it over to Legal Aid lead immigration lawyer Ruth Williams, who will focus on today's content.
Hello, everyone. Thank you for giving up your lunch hour and joining us today for today's webinar on immigration consequences of criminal matters. As we go on, Wyatt already mentioned this, but just keep in mind that this is a public presentation. And if you do have any questions, keep your questions pretty general and not necessarily specific to any one person so that we can respect each other's privacy. Right. Okay, so today's session, I'm going to dive into the intersection between immigration and criminal law, the consequences for convictions, some tips when you do have criminal matters, and then a brief overview on the removal process. I find that having an understanding of how the removal process works provides a context, and particularly if you are an individual who is facing such a precarious situation or you're supporting someone who does, then having a vision of what the timelines are like after a conviction is completed, then it will help you starting now just to start to prepare and turn your mind on how to address that situation. The focus of today's presentation is solely going to be on criminal convictions and charges in Canada. Those of you who might have an understanding of immigration law outside of today will know that convictions and charges outside of Canada can also make someone inadmissible, but our focus today is just on the situation here in Canada. Okay, so the very first place to start is to get an idea of what immigration status puts you at, what type of immigration status puts you at risk of removal when criminal convictions arise. Okay, so there are 3 types of immigration status in Canada. So citizenship, which would be the most stable and permanent. The next type of status that one can have is a permanent resident or a protected person. I'm highlighting here, and I realize I'm very messy with the highlighter, I apologize, but I just want us to focus on keywords. So permanent resident and protected person, those are individuals who are able to work, study, live in Canada without a permit, and are able to travel outside and return to Canada without a permit. Okay, so think of that as if it was a hierarchy, then citizenship at the top, and then permanent residents and protected persons. Protected persons, another term for that would be a convention refugee. It's not someone who is in the process of making a refugee claim. It would be someone who has had the refugee hearing and has been approved, or someone who has been approved for refugee protection abroad and is now here in Canada. Okay, so I just want to be clear with that definition. And then the last is foreign nationals. These individuals have the most precarious and unstable immigration status, right? These are people, they're not citizens, not permanent residents, not protected persons. They're individuals that would require authorization or approval to be able to enter Canada, to work here, to study, right? So those are the three categories. Okay, so now let's talk about some of the intersection, the impact that a conviction has on each of the three categories. Canadian citizenship, as I said, that's the most stable, that's at the highest of the hierarchy. There's no risk, right? There can be some hindrances and some inconveniences that could arise, right? Perhaps there's a loss of a passport, an ineligibility to sponsor a relative. But when it comes to one's status and ability to remain in Canada, not impacted as a result of a conviction. The second type is permanent residence or protected person. That's relatively secure. However, it can be lost in a set types of circumstances. And we're going to talk about the circumstances in which someone could lose it. But an overview of it would be, think of if you are a permanent resident and you were found guilty of a serious criminal offense, engaging in organized criminality, right? Just roughly speaking, if it was a gang or a group of individuals creating, causing havoc or engaging in criminal activity, misrepresentation or security grounds, right? So really high level, serious issues. And then the last status or the last category at the bottom would be individuals who are foreign nationals, right? And so individuals who are foreign nationals, that is the most precarious status that you can have, right? Meaning that the slightest bit of criminal involvement and engagement can result in can result in the loss of status and potential for deportation, right? So even if it's a hybrid offense, right, someone can find themselves losing status. Even sometimes there are some offenses that are summarily dealt with that could result in losing status. We're going to get more into it, but just to give you an idea, these are the three categories. And then as you can see, from the top to the bottom, right, the more impermanent your status, the more likely that a conviction would cause serious problems. Okay, so next, let's talk about a little bit more, give you some definition as to the types of or the definitions or the terms that are used to describe criminality in an immigration setting. So permanent residents and foreign nationals, if they're convicted of, they can find themselves inadmissible for Canada if they're convicted for either a serious criminal offense or straight criminality. Okay, if you look in the Act, in the immigration, so this acronym here, IRPA, stands for Immigration, Refugee, and Protection Act. So again, that's Immigration, Refugee, Protection Act. You can find that online. I've included here the sections that you, or the paragraphs within the act that you can look up to find a little bit more details on the definition. But the two categories are serious criminality and I usually just kind of offhand use, just say, instead of saying criminality, I would say like regular criminality or simple criminality, right? Just to give it something to make more of a distinction between the two. Okay. What does it mean to be inadmissible? Inadmissibility means it's someone who's not allowed to enter Canada. So you can find yourself coming to Canada just as you arrive, as you get off the plane, just as you're crossing the border, just as the ship docks, you meet a CBSA officer and they could say, oh, you're inadmissible to Canada. You're not allowed to enter, right? You have to turn around and go back, right? There are rules in order to enter Canada, and sometimes people who are inadmissible, where it comes to the CBSA officer's attention that you're inadmissible right there at the airport as you're handing in the passport, they can say to you, oh, no, you're not allowed to enter Canada. Okay, so that's one instance. But we're really more talking about people who are already here in Canada, and then as a result of a criminal conviction, we'll find them inadmissible or not allowed to stay in Canada. And those individuals can be subject to a removal order, and in Canada, there are different types of removal order, right? In common parlance, people say, oh, it's a deportation order. But a deportation order is a type of an order. Think of removal orders, the term removal orders, it's an umbrella, and then there are different categories or types of orders underneath. And deportation would be the more serious type of order under the umbrella of orders. Okay, so here, if you're inadmissible to Canada based on serious criminality or straight criminality or plain criminality, then you would be subject to a removal order, which would be a deportation order. Again, I've put here the two sections of the Act, the Immigration and Refugee Protection Act, so you can look at it. The serious criminality applies to both. I'm going to highlight the word both because I want to stress that. It's both permanent residents, remember that's the second category of individuals, and then foreign nationals, which is on the bottom. Okay, when it comes to simple or straightforward criminality, that simply applies just to foreign nationals. So if you're a permanent resident of Canada, you've been convicted of a criminal offense, and it's a type of criminal offense that falls under Section 36(2), under simple criminality, then it wouldn't apply to you because it only applies to foreign nationals. Okay. Now, what is serious criminality? Okay, so serious criminality is when, this is a bit of, there's going to be a lot of words coming here and a lot of terms. I'm going to try and unpack it. Okay, so serious criminality is when you've been convicted in Canada of an offense under an act of Parliament. Okay, I'm highlighting that because that's important to keep in mind. Okay, so first thing is it's an act of Parliament. It's punishable by a maximum term of imprisonment of at least 10 years. Okay, so if someone you're charged with an offense, you look it up in the criminal code. I'm doing this because I'm turning pages because clearly I'm old. I'm not thinking you're looking things online, right? So you're turning the pages in the criminal code, you look and you could see, okay, this offense, if you're convicted of this offense, it has a maximum term of imprisonment. So that's the second point. That's a second factor. An act of Parliament, there's a maximum term of imprisonment of at least 10 years. Or thirdly, right, if there's no maximum that's mentioned, right, or the maximum is less than 10 years, then you'd look at what is the term of imprisonment. If it's more than 6 months has been imposed, then yes, that's serious criminality, right? So those three factors are in play or considered when you're defining whether or not, or you're determining whether or not a permanent resident or a foreign national is inadmissible to Canada based on serious criminality. Okay, so I'll pause for a second to let that land. Okay. So next, we're going to talk about straight criminality or simple criminality, right? And there are going to be different factors to take into consideration. The first factor is it a conviction under an act of parliament, right? So that's the number one. You can see that's the same as serious criminality. Second is, was it punishable by way of indictment? Okay, so that's the second factor. And then the third is, because there might be a conviction or an offense that's not punishable by way of indictment. If not, then the third thing can sort of catch you or trap someone would be if it's two offenses under any act of parliament and it's not out of a single occurrence. Okay, all right. So each one has three factors. For criminality, it is an act of parliament. Indictment is the next key term, and then two offenses not arising out of a single occurrence. That's the third. So I'll stop there and pause, sort of let that land a little bit, right? Because it's a lot of words and I want it to sort of sink in so you have some basic understanding. Okay. So here are some important notes to keep in mind. First is criminal admissibility is triggered by, what I mean by triggered is it's set off, right? At the starting point of criminal inadmissibility in the immigration context is a conviction. It's not a charge. If you are charged with something, yeah, right? Someone could foresee there's the possibility of inadmissibility. But for someone to be inadmissible to Canada, for individuals who are already here in Canada, I'm not talking about people who are coming to Canada, I'm not talking about foreign offenses, stuff that comes up here, then a conviction is what is needed, not a charge. The conviction must be an act of parliament, so municipal and provincial offenses don't count. Okay, so remember it's an act of parliament coming out of Ottawa. The reference to imprisonment, because right here, remember at the top under serious criminality, we're talking about a term of imprisonment. Well, then the reference to imprisonment, it means a jail sentence. Right? Imprisonment in Canada means, in the immigration context, means a jail sentence. Okay? Youth convictions and sentences don't count. Okay? And then lastly, hybrid offenses are deemed indictable. So for those of you who knows, there are some offenses, criminal offenses in Canada that are hybrid, where the Crown can decide, okay, or the prosecutor can decide, hey, this is really serious. We're going by way of indictment because this is a very serious, we want to look for a more significant sentence, or they might go summarily. This is more simple. It's not as serious. We're looking for potentially a lighter sentence. Okay. But in the immigration context, it doesn't matter whether it was dealt with summarily or by indictment. If it's a hybrid offense, if there's the choice, then it's automatically considered indictable. Another point when it comes to youth convictions, while it is not the cause for someone to be inadmissible, please note that youth convictions, youth charges can prevent young people from continuing or completing citizenship applications. It's important that that is taken into consideration. So if you or someone you know who is a youth is having problems with criminality or is engaged in criminality and there's a conviction or a charge, yes, that will impact and put on pause a citizenship application, but please make sure that steps are taken once the conviction is complete, once the sentence is complete. Please make sure that any applications that are put on pause are resumed. Sometimes what happens with families and caregivers is it can get forgotten. And you don't want, right? Remember, I was talking about the hierarchy, first, second, third. You don't want a young person to be here in Canada, right, without the highest form of status in the country, right? Being citizenship. Okay, I've created a little chart here. What are the consequences for convictions? The chart is color-coded. So green is for permanent residents, kind of is how I broken it up. And then yellow would be kind of an orangey yellow. I'll say it's yellow, is for foreign nationals. And I've put smiley faces and frowny faces beside it. So as we go through, you can say, okay, if it's a frowny face, that's a removal order. If it's a smiley face, it's great. We've avoided it, a removal order. And if it's a face where there's some relief, then the person will get a removal order, but will have a chance of appeal. And I'll talk a little bit about that. There are some scenarios and situations where a removal order is going to happen. Right? And I'm using the word removal order because that's really the correct term, but you can interchange it with deportation order, because if it's a criminality, then the type of removal order is going to be a deportation order. Okay, so there are a lot of instances where someone receives a conviction, and even if it's the most minimal. Yesterday we gave this presentation and someone had a question about, well, what if you just received a fine? You know, if it's just a fine, that's great, but it can still make you inadmissible. It could still result in you receiving a removal order. But the lucky thing about having, if you were going to use the word luck, the lucky thing about having, if it's just simply a fine, or if it's a more minimal sentence, is that if you are a permanent resident of Canada, you have the right of appeal, right? You're going to get that removal order, yes, but the sigh of relief here that you see this face is making is because, and again, sorry for my circling is not really neat, but I just wanted to highlight it, is that the sigh of relief is this person has a right of appeal, which means you have a second chance to be able to right the situation. Okay, so let's go through the chart. I'm going to move through it quickly. Remember that you'll get a copy of this, so don't worry about capturing the screen. Maybe just taking 1 or 2 word notes, just so when you do get the handout in the PowerPoint, you kind of remember, you can tie it back to what I said. But don't worry too much about taking notes or memorizing what you see on the screen. Okay, so permanent residents, protected persons. If this person was convicted of an offense where there is a maximum of 10 years and they receive a sentence of more, I'm highlighting the key word here, more than 6 months, then this person is inadmissible to Canada. They're going to be issued a deportation order, and there's no right to appeal the deportation order, right? Hence the frowny face. If it's a permanent resident or a protected person with a conviction, again, same thing, it's a 10-year maximum, but in this case, the person receives less than 6 months or a fine, right? I was just talking about that. They're inadmissible to Canada. They're going to be issued with a deportation order, but then there's a right to appeal the deportation order, hence the sigh of relief, the few. If you're a permanent resident or protected person, the conviction is for a hybrid offense. We still don't know what the sentence is. That's to be determined. That's why the acronym TBD is there. We don't know, right? The person just got the conviction, but we know it was for a hybrid offense. So the key thing to remember is here, regardless of Crown election, whether it went summarily or indictable, the conviction is going to get a deportation order. That's going to happen, right? There's nothing to be done about it. The focus will be on preserving the right of appeal. And a right of appeal only is available to permanent residents and protected persons for a sentence of less than 6 months, right? Hence why in the chart, you have a frowny face and then you have a sigh of relief, because we don't know what it will be. The next and last one is, it's a protected person, right? Or a permanent resident. It's conviction where the term is less than the 10-year maximum, right? So when I'm going to do this gesture again when you're like looking in the criminal code or like scrolling on the screen. And you can see that, okay, this doesn't have a maximum of 10 years. Maybe it's a maximum of 5 years. Maybe there's no mention of a maximum. Well, the most important thing will be, what is the sentence? The sentence is to be determined. So it's less than 10 years. We still don't know what the sentence is. If it's less than 6 months, then there's no immigration consequences, right? Remember, under serious criminality, it has to be like there's a sentence of 6 months. Oh, wait, let me double check. Let me be a good lawyer and double check the wording here. What did I say? Okay, yes, for which a term of more than 6 months. Okay, so it's less than the 6 months, right? There's no 10-year maximum thing, then there's no immigration consequences, smiley face, right? The person's like, phew, okay, dodge the bullet. If it's a sentence of greater than 6 months, then that will result in a deportation order and there will be no right of appeal. Okay. Let's go into foreign nationals now. Now, for foreign nationals, if it's a 10-year maximum, the sentence is still to be determined, right? We don't know if the person has received 6 months or less than 6 months. Well, regardless, they're inadmissible to Canada. The deportation order is going to be issued. There's no right of appeal. That's why we have the frowny face, right? It's a foreign national with a conviction for a hybrid offense, right? But here we go again. And the sentence, even if the sentence is still to be determined, it could be less than 6 months. But regardless of the Crown election, the conviction will result in a deportation order and there's no right of appeal. So again, another frowning face. Maybe we have a foreign national with a conviction for it's 2 straight summary offenses, right? By straight summary, I mean it's not hybrid. It says right there in the act that it's a summary offense, but it's from 2 different occurrences, right? There's a sentence of less than 6 months, but still there's a frowny face because the person's inadmissible to Canada. They're going to be issued the deportation order and there's no right of appeal. Okay, because remember, we have the 2 different offenses. It's 2 different occurrences. Okay, and then the last is it's a foreign national with a conviction for 2 straight summary offenses. They're coming from a single occurrence with a sentence of less than 6 months. Then the person remains admissible to Canada. And so then we have a smiley face. Okay, I'm going to pause there for a second. I see there might be some questions coming in. We'll deal with the questions at the end. I'm just giving a pause just to, because there's a lot of words that are coming at you guys. So just to stop, think, to take a note, and before I get back into it. Okay. Now, what are some of the consequences for convictions? All right. Oh no, sorry. We're still getting into the consequences of convictions. What I want to talk about are what are the results for criminal matters that would not arise or would not have immigration implications. Okay. These can be conditional sentence orders. Maybe there's a discharge. Yay, that's great. Whether it's conditional, absolute, that's perfect. That helps avoid immigration implications. It's an acquittal, a stay of the proceedings, extrajudicial measures. Maybe there's a peace bond or orders under Section 810 of the Criminal Code, or there's a finding of not criminally responsible, right? Any of these, that's a smiley face because we're avoiding these immigration implications. Now, let's get into some important tips, things to remember. Oh, sorry, just give me a second. Okay. Some computer stuff going on. Okay, so some important tips, things to remember when you're navigating criminal matters. So 4 things to remember. This is at the start when there's a charge or when sentencing is outstanding. These are things I want you to keep in mind. So first things first, identify immigration status. That should be something that everyone is doing at the very beginning, right? As soon as you get a charge, whether you are counsel, whether you are a person involved in a situation, whether you're a friend or a family member or someone who's in a situation, making sure that the person's immigration status is identified and noted. The person should be directed to immigration counsel, right? So if you realize, hey, I'm not a Canadian citizen, right? I'm a permanent resident, I'm a protected person, I'm here on a work permit, then getting in touch with immigration counsel to look at the scenario and the situation and start to think and strategize as to how best to navigate the situation. If you are a legal counsel, then consulting with immigration counsel is important, right? If you are someone who's going through a scenario, right? You have a criminal lawyer, you know that you're a permanent resident, say for example, there could be some repercussions. You've spoken to an immigration lawyer. Well, then encouraging your criminal counsel to consult with immigration counsel so that there are 2 legal minds working on the scenario together to help you navigate the situation is best. And then the court should always be alerted because that is a factor in consideration of sentencing, right? What someone's immigration status is. And at this point, because there's been consultations with immigration counsel, then you should be able to explain what is the potential immigration consequences going forward. Okay. Please note that pre-sentence custody that is expressly credited towards a person's, sorry, I just sneezed for a second there. Sorry, second one. Pre-sentence custody that's expressly credited towards a person's sentence, that's noted there. That is taken into consideration in assessing the length of a sentence. So in the immigration context, when Canada Border Service Agency or an immigration board member, so in the immigration tribunal setting, we don't have judges, we have board members. That's the title that people are given. So when a board member is looking at a file and trying to decide, okay, is this person inadmissible to Canada, they will look at what the sentence, what the conviction sheet is, or what the sentence or the conviction certificate and what the sentence is on the certificate. And if there's pre-custody time that is credited towards the person and it's noted, then that could increase the consideration or the length of the sentence. So please do keep that in mind, that pre-sentence custody, when it's expressly credited, can be counted in assessing the length of a sentence. So please, one should be aware of that. And it's important, and I put it here in red because that's how important it is. When we're talking about the length of sentences, we're talking about what is applied to each individual offense, and it's not the global sentence, right? So each individual offense, if it's less than, right, like if we're in a scenario where it's a serious criminality, permanent resident, the sentence is less than 6 months. But it's a number of convictions. It's 2 or 3 convictions, but each is less than 6 months. Then that's a few, right? That person still has a right of appeal because the sentence is less than 6 months. Even though if it was 2 convictions, right? The sentence is served consecutively, right? yes, I think I'm using the right word, if it's consecutively, right, one after the other, then even though that would be a year if you add it together, in the immigration setting, you're not adding it together. You're looking at what each individual length of sentence is. Okay, now I'm gonna I've broken up this portion of the presentation to indicate sort of to like each major category of folks what would be. I'm a lawyer that like loves to give clients homework. So this, if I was working with someone or consulting on a matter, I would say, okay, this is the homework for each category of folks involved, right? So for criminal counsel, right, your homework always is ask everyone about their immigration status. Doesn't matter how the person appears, whether or not the person has an accent or not. Please, it is really, really important that you're always indicating and finding out what is the person's immigration status. And there's different ways you can ask the question, right? It can be a straight question of, what is your immigration status? Sometimes the way that's phrased, it goes over people's heads. So you could ask, where were you born? Where were your parents born? And that kind of helps focus to have an idea of, okay, is this person, what you're trying to understand is this person a citizen, a permanent resident, or just a straight foreign national? And then once you figure that out, then you'll know, okay, I've got to contact immigration counsel, right? So that's your homework, right? You're going to find out what the person's status is. You're contacting immigration counsel so that you can come up with a plan to sort of minimize the immigration impact for someone. If you are an immigration service provider, you are someone who is a justice navigator, a social worker, an agent in an organization that supports newcomers or permanent residents here in Canada. Well, then your homework would be just help clients that you serve be able to determine and prove their immigration status in Canada. Because it might be one thing, the person might say, oh no, I'm a citizen. I know I'm a citizen. Well, proof of your status in that person's status in Canada would be a birth certificate or a passport. And so helping the person sort of locate these documents, go through sort of like the shoebox, right? To figure out, okay, do we have the paperwork that matches what the person is saying? If the client that you are serving is unrepresented, we'll think helping them with being able to get legal representation, right? Encouraging them to go to court, connect with duty counsel, contacting legal aid, right? Getting the resources and the help that they need to be able to navigate the situation that will be unfolding before them. And then lastly, and really most importantly, is helping the clients navigate sort of this legal labyrinth that they're going to go through. The court appearances and keeping track of dates and gathering documents and working on a rehabilitation plan, right? Those are all things that people would greatly benefit of getting the support. For person concerned, right? So you're someone who, okay, this is the scenario, this applies to me. Well, your homework would be confirming your immigration status at the start of the criminal proceedings, right? So letting people know, getting those documents, discuss with your lawyer the immigration consequences, right? So having your lawyer get the information that is needed so that they could inform and advise you as to say, okay, this is what would be the consequences for your situation. And then most importantly, following that legal advice and information. So starting now in working with your lawyer, the justice navigator, social workers, other people in your support systems, family members, friends, to deal with your criminal charges and then any future immigration charges. Or future immigration charges, I meant future immigration matters. Okay, when to contact legal aid, right? So if you're in this scenario, when you're initially charged, please make sure you're contacting us for assistance with your criminal matter. After conviction, please absolutely call us when CBSA contacts you, right? We can assist with detention reviews, admissibility hearings, removal appeals, right? These are the things we can help with. So give us a call. Unfortunately, we cannot assist with some of the preliminary things or other things that happen when you find yourself in where your immigration status is, you've completed the conviction and your immigration status is being challenged, right? So procedural fairness letters or pre-removal risk assessments, humanitarian compassion applications, deferral requests, stay applications. These are citizenship applications and judicial reviews. These are things we're not able to assist with. Okay, so just being mindful of the time, I'll quickly go through because we're at the end and I want to give us a good 15 minutes for questions. So here's an overview of the removal process. If you are a permanent resident or a protected person and you received a sentence of less than 6 months, then once you've completed your sentence, CBSA will contact you with a procedural fairness letter. You'll remember I referred to it earlier. A procedural fairness letter is a letter from CBSA that alerts you to say, hey, you're potentially inadmissible to Canada. You've been convicted of this offense. Please write to me and let me know, right, why it is you think you should be allowed to stay in Canada. That's what a procedural fairness letter is. Once you get such a letter, you'll absolutely want to connect with Immigration Counsel. While Legal Aid is not able to provide you a lawyer for such a response, connecting with counsel would be most beneficial to make sure that you're responding and getting the assistance that you need to provide a really fulsome, strong argument as to why you should be allowed to stay. After receiving the procedural fairness letter, CBSA will decide, okay, should we continue with this removal or not? If they think they're going to continue with the removal, and then they will write up what is called the Section 44 report. The Section 44 is just a reference to the section or the paragraph in the Immigration and Refugee Protection Act, right? It's the type of report that's written. And then that report is written up and they send it to the Immigration Division out of the Immigration and Refugee Board to schedule an admissibility hearing. An admissibility hearing, remember, admissibility the definition was whether or not you were allowed to stay in Canada. Well, an admissibility hearing is someone, an immigration board member, remember, we don't have judges, they're called board members. The board member decides, hey, is this person admissible to Canada or not? Right? Once the Immigration Division receives a request for an admissibility hearing, it's scheduled. If the person received a sentence of less than 6 months, remember I said the deportation will still be issued, right? So when you go to the admissibility hearing, be aware that the member is going to order the deportation, but the saving grace is that the person is allowed to appeal the deportation order to the Immigration Appeal Division and then potentially regain their status. If you have gone through this process, you know who someone has gone through this process or they're at the start, just remind folks that we do provide lawyers for removal appeals to the Immigration Appeal Division, so you can contact Legal Aid for help. The second scenario, going a little faster now, right? This is a situation where someone has received a sentence of more than 6 months, right? So the sentence is done, the procedural fairness letter comes, the report is written, the hearing is done, right? The deportation order is issued, but now this person does not have a right to appeal. Well, then CBSA will begin the process of removal. Please make note, there's no formula as to how quickly CBSA will start the removal process. It can be weeks, it can be months, it can be years, right? It eventually does happen. It's just there's no way of knowing the time frame. Okay? What does that look like when CBSA begins the removal process? Well, the person's called into for an interview, a pre-removal risk assessment, right? That's PRRA. A PRA is offered. Remember, Legal Aid does not provide people with lawyers for that. So you'll have to hire a lawyer privately if you're in that scenario. If the PRA is unsuccessful, then removal is booked and the person is escorted home. This time frame, again, I can't tell you how long or short that takes, but this is roughly what it looks like. And then if you are a foreign national, you're convicted of an inadmissible offense, right? Then you're in a situation where CBSA is going to write up the report, but there's no procedural fairness letter. I'm highlighting this here, right? No procedural fairness letter is required or admissibility hearing. So when you get that Section 44 report from CBSA, if you're here on a work permit or a study permit, then that's your first alert to say, okay, it's your status is no longer valid, you're inadmissible. CBSA usually will call someone in, read through or show them the Section 44 report, have the person sign, and then book an appointment for the person to come back to start the removal process. Okay. So we're at the end of my presentation. I'm going to stop sharing my screen. Okay. And then some questions.
Hey, Ruth. So yeah, so just as a reminder for folks, we do have the Q&A feature that you're able to ask questions. And as mentioned, we might not be able to get to all questions, but we'll try to get through as many as we can here. So just starting with kind of chronologically, so we had a question about having access to presentation, which yes, we'll send out via email, hopefully later today. There was a question just confirming acts of parliament. Are you able to just go over the distinction again between an act of parliament, Ruth, versus like a city bylaw or what have you?
Okay, so an act of parliament is, we're talking about the criminal code is an act of parliament. The Immigration Act is an act of parliament. So their legislation that comes out of their legislation are acts that have been created by the federal government. Provincial offenses, right, or city offenses like city bylaws, that sort of thing, are not considered acts of parliament. So if you find yourself where you are in trouble because of a provincial offense or a city bylaw, then that's not going to result in you being inadmissible to Canada.
Perfect, thanks. We just had a quick one here. If a person was born in Canada from parents who were born abroad, are they, like, which category would they fall into for these conditions?
Yeah, if you're a person who was born in Canada, though your parents were not born here, like myself, then you're safe. You're a citizen, right? You have, in Canada, the right of citizenship applies for individuals who are born here.
Right, thanks. So a question, sorry, a little bit of a longer one. A conditional sentence order is a custodial sentence that is served in community post-conviction. If the order is breached, it can result in actual jail time. So they were just asking why there are no immigration consequences for a conditional sentence, and then does it depend if the person successfully abides and whether they do not serve actual jail time?
Okay, so thank you for this, because if the order is breached and it results in jail time being served, there are actual immigration consequences for the conditional sentence order. Wait, no, pause, let me rewind. When I said there was no, I should clarify, when I said there is no immigration consequences, meaning that what I meant was that if it's more than 6 months, and I'll make sure to fix this in the PowerPoint before it goes out for you folks, so you can reference it. When I said there's no immigration consequences, what I meant is that you can still get the deportation order, but it is a deportation order that is appealable. So in an immigration lawyer's mind, it's like, oh, there's no consequences because you can still appeal it. So my apologies. Yes, there are still consequences. It's just simply that the consequences are such that you still have the right of appeal, because you can, because the it's the term of imprisonment that is what counts. I imagine, though, if you're in a scenario where you received a conditional sentence order for an offense where there isn't the maximum term. Sorry, I'm trying to make my brain do the leaps. If you receive a conditional sentence order for an offense where the maximum term is not 10 years and it's a straight summary offense, then it could be a scenario where, it could be a scenario where there wouldn't be immigration consequences because you would not be inadmissible based on the definition that's given in the act. So you kind of really have to look at the scenario because it could fall both ways. So yeah, good point, Camille. It could, the knife can cut, I mean, it could fall both ways. You can be on either edge of it. But really the most important takeaway when it comes to a conditional sentence order would be that if it is, even if you receive a conditional sentence order and it is greater than 6 months, you still have the right of appeal because it's imprisonment that is what counts, not a sentence that's served in the community. And then the other part to your question that would be helpful to keep in mind is if the person ends up having to serve actual jail time, right, depending on how long the conditional sentence order was for, or like how good they were and then what's left on the order, they might find themselves where the rest of the time, if it's more than 6 months, then it not only are they inadmissible to Canada, they don't have a right of appeal. So I'm sorry that was a bit complicated. I promise I will take the time in the PowerPoint presentation to make it more clear and write it down so that's in writing so you guys don't have to remember my stumbling through that answer.
No worries, Ruth. Thanks so much. So we had a question. So if a permanent resident breaks the conditions of a stay by getting a new criminal conviction, how might their mental health issues affect the judge's decision in their immigration appeal? And how likely is it they can remain in Canada?
Yeah. Yeah. So, yeah, sometimes if you're talking about the conditions of a stay, if you're talking about a conditions of a stay for an immigration matter and they get a new conviction, their mental health issues absolutely are taken into absolutely taken into consideration by the immigration board member. But sometimes that can go either way, right? Like, so sometimes the mental health issues can be a mitigating factor that's supportive of someone if they receive the conviction and then they're back again. But there can be instances where a new conviction does not help, right? Is seen as an aggravating factor, and their mental health is seen as an aggravating factor. And another thing to keep in mind, if someone is on the condition of an immigration, like they're on an immigration stay, if there's another conviction and it's a conviction that makes them inadmissible, for which they would not be able to appeal to the Immigration Appeal Division, then their stay is canceled, the immigration, the removal order is upheld, and then the person is inadmissible to Canada without the right to appeal. So.
Thanks, Ruth. So we had for immigration purposes, when a person pleads guilty or is convicted after trial and receives a conditional discharge as a sentence, is that considered a conviction?
Is convicted after and receives a conditional discharge as a sentence. Okay, so now this is where my ignorance when it comes to criminal law. Conditional discharge, that would be, if my understanding is correct, the conditional discharge is there is no sentence, there's no jail time. So if it is a conditional discharge, then I mean, if there's a conviction and it would still show up on their criminal record, then it is a conviction and there still are immigration consequences. But if there's a conditional discharge and there's no criminal record, then there wouldn't be an immigration consequence. But, oh, yikes, anonymous, I hope I'm understanding conditional discharge properly. And if I'm not, please save me from my embarrassment and write me and tell me I'm wrong.
That's just another point why this is, a complicated subject. So we always recommend that if you are dealing with something personally, make sure, to follow up with an immigration lawyer or criminal lawyer so that you understand what your rights and options are in any given situation. The question, if a person with permanent resident status in Canada is alleged to have committed a criminal offense abroad, can that impact their status in Canada and can they be removed? That was from Miriam.
Yes, absolutely. Yeah, no. So I didn't talk about that, and that might be an idea for another presentation. Because if someone is a permanent resident here in Canada and they find themselves where there's an allegation, right, of committing an offense, it could be a charge. It doesn't even have to be a conviction. If there's a foreign offense, there would be an equivalent here in Canada. They can find themselves where they could be removed. And if you know someone in this situation, the test for determining equivalency is really complex. So this is something where the person should be referred to speaking with a lawyer and having a lawyer sit down and look at it kind of line by line to clarify things. Yeah.
Okay, thanks, Ruth. We'll try to get through maybe a couple more questions here because we are starting to run up to our 1 o'clock time period. So we had a question. So what about for violent offenses to which jail time must be served? They're just referencing they know of a few situations where permanent residents were convicted, served jail time, and upon release, they were not deported. Are you able to provide a bit more background on the potential reasonings behind why that might be the case?
Yeah. So the fact that someone was not deported, right? So not physically removed. Sorry, I'm a hand gesture person. So the fact that someone's not physically removed from Canada does not mean that there were no consequences, right? What it can mean is that the person is inadmissible to Canada. Maybe they have not had an admissibility hearing yet, right? So basically CBSA hasn't caught them yet, or right, like their immigration consequences haven't caught up. So that could be one scenario, right? So they've been convicted. CBSA simply just hasn't gotten to contact them with the procedural fairness report and the section 44 and right? So it could be that. There are some people who committed a violent offense. They've been convicted. They're released. They receive a removal order. So they've had the admissibility hearing, but they're still not removed from Canada. And that can be a scenario or situation where the person is from a country where Canada cannot remove them. In Canada, there are categories of countries because as a country where we respect human rights, part of our international obligations are that we do not remove people to countries where they would face a risk of harm. And so there are different categories of countries where Canada would say, hey, even though this person is inadmissible here, we are not removing them because the country to which we would be sending them back would be so extremely dangerous. And individuals in that situation, they would be under conditions and observation by CBSA to make sure that to make sure that this person, or to minimize the person's risk in the country. So that is one potential scenario. So those are two potential reasons or scenarios as to why someone has not been removed from Canada.
So just on behalf of Legal Aid Alberta, I want to say thanks to Ruth for taking the time today to share her knowledge and expertise. As a quick recap, for everyone, we are sending a copy of the PowerPoint that Ruth presented, as well as a recording. We'll try our best to get it out by end of day today, so that way you have it while your mind's still fresh. And otherwise, I just want to say a big thanks to everyone for taking the time to join us on Friday. Depending on where you are in the country, hope you're braving the snow or the cold. But otherwise, we'll see you at the next Legal Aid training, and thank you again for joining us today.
Thanks, everyone.